This is the fourth video in a series of videos providing an overview of the Wales safeguarding procedures as they relate to children at risk of harm. Running alongside this video is an additional video that provides you with a guide on Section 3, Part 2, as it is presented on the app itself. Section 3, Part 2 covers the process and the responsibilities in relation to decision-making and initial child protection conferences. Before we move into this part of the procedures, a reminder of the process that has been followed up to the point of the initial child protection conference. So the safeguarding concern was raised and discussed with a line manager or designated safeguarding person. From here, the report was made to social services, received by them, and an initial decision reached that there was significant or sufficient information to have concerns that a child was at risk, which led into the strategy discussion. The determination from the strategy discussion or meeting was that Section 47 inquiry was required in order to determine if a child was experiencing or at risk of experiencing significant harm. The Section 47 inquiry has concluded that there is information and sufficient evidence to suggest that the child is or is at risk of experiencing significant harm, and so the decision has then been taken to initiate the initial child protection conference. The purpose of the initial child protection conference is to make the decisions that are needed about the child's future safety, well-being and development. It brings together family members and the child where appropriate with their supporters, advocates and practitioners who are most involved with the child and the family in order to reach the decisions stated. The conference will determine, the initial conference in particular, will determine whether the child is at continuing risk of significant harm, and as a result requires a care and support protection plan and registration onto the Child Protection Register. The initial Child Protection Conference will be convened by social services within 15 working days of the last strategy discussion or meeting. And the procedures suggest and advise that that initial conference should not last more than 2 hours. Where agencies are invited to the conference, they will be required to provide a written report that is given to the chair 2 working days in advance of the conference, and that report is shared by the agency, discussed and explained with the families at least 1 day prior to the conference. In practice, this does need to be more than 1 day in advance in order to enable the family to digest, to understand, to process the information within those reports, in order for them to make an informed contribution at the conference meeting itself. Within the procedures, there is the description of the information that needs to be contained in agency reports that are made for the initial child protection conference. In terms of the decision-making process that will be made at the initial conference meeting, there are 5 key stages that will be followed, and we will explore each of the 5 stages in the next couple of slides. So to begin with, there needs to be a summary of the information about the risk of significant harm. And in summarising the information, the procedures advise that consideration is given to the following questions. What do we know about the cause of harm and impact on the child? What are our concerns about parenting capacity, family and environmental factors? What do we know about protective factors and family strengths? And equal weighting needs to be given to the strengths as much as the concerns. The next stage then is to make sense of that information in order to establish why practitioners have their concerns. And the question to be considered is whether the risk of harm and concerns about parenting capacity outweigh the family strengths and protective factors. In response to this question then, the decision needs to be sought as to whether in the collective professional judgment of the group, the child is at continuing risk of significant harm. And if the answer to the question is yes, in our professional judgment, the child is at continuing risk of significant harm, then registration onto the Child Protection Register should be considered. If the answer is no, then consideration needs to be given as to whether a care and support plan is required. If the decision is reached at the conference that the child's name is to be placed onto the Child Protection Register, the group will need to determine what category or categories best describes the ongoing risk of harm to the child. And from that, the care and support protection plan is then required to be developed. But in developing that plan, consideration needs to be given to what needs to change. What must parents do themselves, and how can practitioners support and facilitate the changes that are required? The reaching of those decisions, the sharing of the information, will be undertaken by a number of people attending the conference, and the responsibilities of the key participants of the initial Child Protection Conference and any subsequent conferences firstly start with the chair. So the primary role of the conference chair is to ensure that it is child-centred and that the protection, care and support needs of the child or the children are identified and addressed. The care and support protection plan coordinator, who will be the child's social worker, must ensure the child and the family have a clear understanding of the planned outcomes, that they accept the plan and are willing to work to it. Now, that may involve numerous conversations. It may involve information being presented and shared with them in different formats. The Care and Support Protection Plan Coordinator is then responsible for coordinating the preparation, completion, review, delivery, and revision of the plan. And they are required to see the child at least every 10 working days to ensure that the child is seen at home at least every 4 weeks. There are also, however, responsibilities for the practitioners attending the conference. The procedures set out that the responsibility of the practitioners at the conference include objectively analysing the situation, which includes any concerns, information or findings gleaned through the Section 47 inquiry. Objectively analysing the family's strengths and protective factors, and objectively analysing any previous knowledge of the family and service involvement. The practitioners are responsible for deciding whether the child is at continuing risk of significant harm and what future action is required to safeguard them from that and to promote their well-being. Practitioners will be required to present their agency report, summarising the information and highlighting the important points. And in doing so, they may be asked or expected to interpret, analyse and explain their information. And they will be required to provide a view at the initial conference, any subsequent conferences, as to whether the child is at risk of harm and their name should be placed and or continue to remain on the Child Protection Register. It is important that we make sure children and young people are given a voice in the conference. They provide a key source of information about their daily lived experience and the impact any problems, any challenges, any experiences the family may be having is having on their lives and their lived experience. children and young people, for them to be able to feel that they can have a voice, to contribute to the conference, to contribute to the discussions, decisions being made about their lives, need to feel that they're supported to express their views, that they're empowered to have their own voice, that the professional's voice is not the dominant voice that's being heard, that their involvement is recognised as important, and that they are helped and reassured that their contribution is valid, so that they feel positive about the experience. So how do we support and enable children and young people to have a voice in the conference? We need to see it as participation, not attendance. Everybody at that conference needs to provide the child with the voice, that we don't see them as a passive conference member who is sat in a meeting. To do this, we need to support their participation in different ways, but that we do that in a manner that works to their strengths, that works to their preferences and their choices. And this could take many forms: advocacy, supporting their attendance, that their viewpoint is provided in the report of the social worker or other practitioners trusted by the child, for example, at school. Information about any direct work that a practitioner has undertaken with them prior to the conference. They might write a letter, send a text, draw a picture. We also need to make sure that the child is fully supported in preparation for the conference. So we're not simply seeing the child arrive on the day of the meeting. The process, who will be there, the nature of the discussions, the decisions to be reached needs to be explained to them in a manner that they can understand. It might be that a practitioner takes them to the venue where the meeting is taking place, works with them to identify what it is they are going to want to say, and do they need information presenting in different formats. Then during the conference, make sure the child meets the chair prior to the conference. Be clear about which parts the child can't attend and why. And try and get that child settled into the room before professionals enter, so they don't feel daunted by numbers of adults walking into the room after them. As the chair break the ice, relax everybody, make that child feel as relaxed as possible. And everybody needs to ensure that they are avoiding the use of jargon. And then after the conference, debrief, support the child after the conference, give them the opportunity straight after the meeting, straight after the conference, give them the chance to discuss their feelings. Provide clarification, clearly explain the discussions and the decisions that were reached, and provide the child with positive feedback about their contribution. As well as the child's participation at the conference, it's also important that parents or caregivers are actively encouraged to attend the Child Protection Conference as well. The child social worker is responsible for making sure the parent is informed about the outcome of the Section 47 inquiry, that they are helped to prepare for the conference, that they ensure the parent understands the process that will be followed, which includes the purpose of the conference, how it operates, their participation, their role, their contribution, who else attends, and the possible outcomes that could be reached. Help the parents to prepare for the conference. There will be a lot of information that is shared during that initial conference and any other subsequent conferences. When making decisions, it's important that practitioners recognise a number of key points that take into account, consider a number of different factors. So it's important to recognise that the focus is on the actual likely and/or ongoing risk of significant harm. That a decision is made separately for each child in a family. taking account of the harm they are or are likely to experience and the impact on their health and development. This could differ from one child to another within one family. All practitioners attending a conference are part of the decision-making process. They cannot abdicate their responsibility, however difficult some of the decisions may be. Those attending the conference and hearing the information provided will be asked to provide a view on registration for each of the children being discussed. Under the new procedures, the social worker will not present at the conference their recommended view in terms of registration. It will be a collective decision. So what are the key considerations then in relation to decision making at this initial conference and possibly any subsequent conferences that may be held? The key here is preparation. All practitioners attending need to prepare the summary of their report that focuses on the key points they wish to make. But in drawing on the evidence and summarising the key points, it's important that the focus is on the child. It's remembering that the focus of the conference is twofold. Firstly, to make sense of the information, and secondly, to construct the plan to address any concerns that may be there. Central to understanding the level of risk of harm is having that sound understanding of the daily lived experience of the child. Remembering that every child is unique and their needs will be particular to them as an individual child. Again, reinforcing that each child is considered separately. It's also important to recognise and to consider that each parent, where there is more than one parent present and involved in the life of that child, has a responsibility to keep the child safe. Their roles and responsibilities as parents should be considered separately. Whilst the tendency will be to primarily focus on the risk around the child, it's important that professionals, through their assessments in relation to safeguarding concerns, consider the family strengths and that there is a balance of the concerns and the strengths of the family with the relevant supporting evidence. Anybody attending the conference must be prepared for an open discussion about professional concerns and strengths and to participate in these discussions. It is not helpful for information to be disclosed and shared between professionals once the conference meeting has concluded, because the discussions, the decisions made during that conference will determine the next steps in relation to the safety and welfare of the child. When as a group, the outline care and support protection plan is being developed, it is important that the actions aren't the sole focus. But when we are considering the actions, that they're considered in context. By asking questions such as, what are the needs that need to be addressed? What actions, support, intervention, advice, guidance can address those needs and why? And how will we know if the actions are being effective in relation to child-centred outcomes? We need to remember it can be disempowering for parents and carers, and it can inhibit change if we only focus on concerns at the conference. Therefore, once again, the importance of recognising family strengths, identifying how they can be developed, enhanced, in order to improve the daily lived experience of the child or the children. So, following the sharing of the information, the open discussions, having given consideration to the points that have just been raised, the practitioners within the conference will need to determine whether a child is at continuing risk of significant harm and requires a formal care and support protection plan and registration on the Child Protection Register. This decision will depend on the child has suffered ill treatment or impairment of health or development as a result of abuse or neglect, and practitioners' judgments are that further ill treatment or impairment is likely. Or it is the practitioner's judgment that the child is likely to suffer ill treatment or impairment as a result of abuse or neglect. It's important to note that whilst the views of the child and the family in relation to the risks of harm must be taken into account, it is the practitioners at the conference who will make the decisions. The decisions being whether the child is at continuing risk. So if the child is not at continuing risk of harm but may have needs for care and support, then the parents will be encouraged to participate in a Part 3 care and support assessment. Part 3 being Part 3 of the Social Services and Wellbeing Act. It could be the decision is reached that the child is experiencing or is at risk of harm, and as a result, they should be placed on the Child Protection Register and made subject of a care and support protection plan. If it is determined that a child's name is to be placed on the Child Protection Register and that they will require a care and support protection plan, the conference will formulate the outline plan in order to meet the child's needs. The outline plan will include information about the way in which that plan will protect the child, the shorter and the longer term planned outcomes that are to be achieved, the provision of any support and who will have responsibility for what actions and any specified timescales, and also the arrangements to monitor and evaluate progress against the plan. A copy of the outline plan and a summary of decisions made at the initial Child Protection Conference should be circulated then within 5 working days. The content of the outline care and support protection plan must detail the following information as set out in the procedures. So it includes the risks of harm to the child and the nature of those, the way in which the multi-agency plan will protect the child, shorter and longer term planned outcomes to be achieved, but within this clearly linking outcomes to reducing the risks of harm to the child and promoting their well-being, and the provision of any support, treatment or therapy, including ongoing advocacy. It must also detail who will have responsibility for what actions and within what specified timescales, the arrangements to monitor and evaluate progress, and which practitioners will monitor the child's progress, development, well-being and safety, and also how. And just as importantly, the wishes and feelings of the child and the views of the parents, insofar as this is consistent with the child's well-being. It's important that the boundaries of confidentiality are adhered to, but within these boundaries, individual practitioners should contribute all relevant information that they have on their records, but the information received during the safeguarding process is treated in the strictest of confidence. Parents and carers will receive a copy of the full record of the conference unless the chair and conference members decide that it is not appropriate. There are a number of circumstances when personal information, must be disclosed. That is when an individual exercises their right to request personal information, a request has come through court and legal proceedings, a practitioner is required to make a disclosure, and or it is in the public interest to share the information. The procedures also specify additional tasks for the conference, and these include confirming the Care and Support Protection Plan coordinator, who will be the child social worker, identifying the membership of the core group of practitioners that will oversee the delivery of the Care and Support Protection Plan, establish how children and families will be involved, and set timescales for core group meetings and the production of the Care and Support Protection Plan. The core group should then meet within 10 working days of the date of the initial Child Protection Conference, and thereafter at monthly, but no more than at 6 weekly intervals. So to bring section 3, part 2 to a close, the important points to note here in relation to the shift in culture and practice. Firstly, that the only decision that was previously made at the conference, at the initial Child Protection Conference, was whether or not the child's name should be included on the Child Protection Register, and if so, under which category. There are now 2 decisions that could be reached at the initial conference. The first being the child is not at continuing risk of harm but may have needs for care and support, which would then trigger any duties under Part 3 of the Social Services and Wellbeing Act to assess care and support needs. Or the second decision could be that the child is experiencing or is at risk of harm and is registered on the Child Protection Register and made subject of a care and support protection plan. Previously, the determination of the appropriateness of registration will have been predominantly focused on the level of risk. The determination of the appropriateness of registration is now informed by a balance of managing risk, meeting care and support needs, and achieving the child's personal outcomes. And we see a change in terminology from a named key worker to a care and support protection plan coordinator. It's important to note that this change isn't simply a change in the name, but the responsibilities of the Care and Support Protection Plan coordinator are now clearly set out and described in the procedures.